Perfect. So we're going to go ahead and get started. So thank you so much, everyone, for joining us this afternoon for our session on how to restrict the movements and lending capacity of your debtors with our featured expert, Erin Prout from Taurus Legal. We do have Erin with us, and as well as Jody from Taurus Legal. Jody is a practice manager, and so basically she's the one that kind of runs the business, much to the chagrin of the CEO. And but I'll talk a little bit about Erin and her background and why it is that she is speaking with us tonight. So once again, welcome. I'm Wendy Dawson, the Chief Brand Officer for Victory Offices. And even though this is a webinar on behalf of Victory and Taurus Legal, we would like to respectfully acknowledge that we are meeting on the traditional land of the Kulin Nation, and we pay our respects to the elders past, present, and elders from other communities who may be here today virtually. So what is today's session all about? Well, the last couple of years have been tricky, hasn't it? It's been interesting. If you've been able to kind of make money, to be in business and all of that, it can be a challenge when the people you're doing business actually owe you money. So what can you do? So in this webinar, we're going to learn about what you can do to restrict the movements and lending capacity through bankruptcy and insolvency. You're going to learn how those processes work, how they differ, but also the consequences. And sometimes they're quite harsh and can last a lifetime. So they're a great way to perhaps induce some payment from the people who do owe you funds. Having said that, our expert in the house is Erin Prout. Erin is an experienced litigator and commercial lawyer. She practices across a range of commercial matters. However, her specialty is litigating and resolving contractual disputes and debt recovery. Erin prides herself on her commercial nous and acknowledging that a resolution must be tailored to address the parties' ongoing relationship, amount in dispute, and underlying interests. Erin is also an integral part of our commercial practice at Taurus Legal, and she focuses on drafting business agreements. One of her key principal areas is ensuring that these agreements are actually strong and fit for purpose so that they protect the needs and requirements of her clients. So without further ado, I will hand over to Erin. Please feel free to, at times, ask questions in the chat box, but we'll do a Q&A session at the end. And I'll probably turn on, if you want me to turn on your camera and microphone, we will. But if not, just go ahead and submit your questions in the chat box. Over to you, Erin.
Thank you. Good evening, everyone. Let me just share my screen so you get presentation. Here we go. So let me talk a little bit about us. So you already know I'm from Taurus Legal Management. What we do is we are dispute resolution specialists. Wendy's already given a little bit of a brief about who I am with Taurus. And so I started off my career purely in debt recovery, pursuing debts and recovering them. And that was contract based, whether that was a written terms and conditions or an oral arrangement. And then from there, I've built that practice. And I've also done a master's which focused on contract interpretation and dispute resolution and mediation. And what we do is we're distilling all of that practical knowledge into something that you can actually implement in your business. So that's recognizing an immediate dispute at hand, what you can do to resolve that dispute, and then looking forward to how we can stop that dispute from happening again in the future, and help you and your business reach the goals that you want to be at. Specifically, today we are focusing on bankruptcy and insolvency and what you can do to to, oh, sorry, let me just go back. Here we go. To learn about those processes and the consequences of them. That's what we're really focusing on today. And then as well as those processes, we're going to look at a couple of less legal options. So things that you can do yourself to recover these debts and to restrict what these debtors can do. Unfortunately, this is becoming more and more common. It's kind of been the prompt for why you're all here today. We're getting a lot of cases for debt recovery and fraud, and particularly cases where funds are being taken or not paid, and then that person is absconding overseas or going off and spending your money. So we want to work out how we can stop that from happening to you. This is a case of ours that was in the last year. And what happened is the clients came to us and said, oh, look, we've been referred to a financial advisor by someone that we've known our whole lives. They said how great this financial advisor was. So we, had a phone call with the financial advisor. It all sounded very good and promising. And then from there, we agreed to meet with them. We went to his office. At his office, he had a slideshow ready to go about a property development in Malvern. And then he said to us, if you transfer your super into a self-managed super fund, I'll then invest it in this property development in Malvern. And then here's an estimate of the returns you'll get over time. And this is how your retirement can look versus what it looks like now. And that's actually on the screen, a photo of the completed development now. It all looks very lovely. And so based on that advice, the clients agreed, invested all of their life savings, their superannuation as well. And it all sounded very good. At the start, they were getting some updates from the financial advisor. They were getting a few building reports about how the development was going. And then after a while, it all went quiet. They didn't hear anything. They couldn't contact the financial advisor. And then they did some searches themselves and found out that the townhouses were actually being sold. So that's when they came to us, and it turns out that the financial advisor actually had never invested any of their money in this development. And there were another 20 people or so who'd done the same thing to, all of them ranging from $500,000 or so into the millions each. So this is, over a $20 million fraud. And the worst part for all of these people was that he had gone overseas and was posting on social media, lavish holiday he was having. He was out driving sports cars. He was out on boats. He was really living the life, and all these people could do, really, all they felt like they could do was sit and watch him go and spend their money. So that's what we want to try and avoid for you guys today. This is probably one of the most severe cases of it, but there's things that we can implement and we can talk about today, which will helpfully stop it before it gets to that point. So then the legal options that you've got, the main one is bankruptcy, and that's for an individual only. The similar process for a company is liquidation. Then we'll also have a quick look at an injunction or search order, and that can be for either an individual or a company. And then we've got some other options like garnishing wages. That's for an individual only, and that is taking a percentage of a person's wage before it goes into their pocket. And the last one is seizing and selling assets, which can either be to an individual or a company. So today we're focusing on the first three of those because they primarily restrict movement and also affect lending capacity the most. And then the other options that you've got are less legal options. So the one that's great for you guys is to implement notifying credit reporting agencies. So any bank or company that is advancing funds to an individual or to a company will look at the credit rating and will look at whether there's been defaults on credit ratings. And if you do searches now of companies, any person can do a search of a company through ASIC. If you do it through a search provider such as InfoTrack, what they actually have on the end of that company search now are current defaults reported to credit agencies. They have the number of defaults, the figure, the dollar amount of that default. And they also have on there who's requested a copy or who's done searches. So you can see if it's a company that has a number of defaults and there's a number of people searching it, they're probably not someone to lend to, and they're probably shopping around a lot to try and get these funds because everybody's doing a search on them. The other one is notifying your insurer. This is if you have a debt recovery insurance. And it's really common in industries like labour hire. People tend to have an insurer. And then the last one sounds a bit obvious, but not a lot of people do it, which is notifying the police. Obviously, for the last one, if it's just a debt that's outstanding and that's it, it's a civil matter, not a criminal matter, which the police will be able to help with. But in instances of fraud, it is both criminal and civil. So you can go to the police and report the fraud. My advice would be to go to your local police station and then ask your local police station for the details of the fraud squad or the fraud investigative unit, because they're far more well-versed in dealing with fraud complaints and will know how to pursue them better than just your local police station. So when we talk about these different options today, there's a range of different factors you should take into account. There's no necessarily right or wrong answer, and which way you choose to go depends a lot on the circumstances of your case. But at the very minimum, you should consider, is it going to be commercial? Am I going to be spending more money on legal costs than what I'm owed? Then is it practical? So when you have a legal proceeding, you're required to serve legal documents on that person. Are you going to be able to do that? Have they moved overseas? Do you know if they've moved their assets already overseas? Is it going to be more time and more cost for you to go ahead and do that? Are you ready to settle into that process, which could take more than 6 to 12 months? And then finally, recovery. So picking the option that's going to give you the best means of recovery. So, you know, at the start, we talked a little bit about garnishing wages, which is taking a percentage of wage, and seizing and selling assets. If somebody is on a $100,000 wage or salary, you're garnishing their wages makes more sense than doing it to somebody who's on $50,000 or $60,000, because you're only going to get, you know, $100 a fortnight, and that's going to take so long. Whereas if they have a car or a boat or a house, seizing and selling that asset is going to be much quicker and pay you the whole of what you owed, like most likely, compared to garnishing somebody's wages or doing one of the other options. So you've got to work out where those assets are, and then, you know, consider which option you go down. The first of these that we mentioned before is bankruptcy. Now, bankruptcy is a very technical area of the law, and I could spend hours explaining bankruptcy to you, but you'd all probably fall asleep. So this is the very basics. You need a debt of $10,000 or more. And the process to make somebody bankrupt is you have a bankruptcy notice, and then you issue a subsequent court proceeding, which is a bankruptcy proceeding. And to issue that bankruptcy proceeding, what you need is an act of bankruptcy. And there are a number of different acts of bankruptcy under the Bankruptcy Act, but the vast majority of cases rely on a failure to comply with a bankruptcy notice as the act of bankruptcy. So you send out a bankruptcy notice, they don't comply, then you have a presumption, an act of bankruptcy, and you can start that next legal proceeding. If you are successful in that bankruptcy proceeding and the court orders for that person to be made bankrupt, they'll appoint a trustee in bankruptcy. And what that person does is they take over control of that person's finances, all of their assets. And the benefit of making somebody bankrupt is that you have control over who that trustee is. So you can be strategic and appoint somebody that has good results that you've worked with before. But if you don't appoint someone, it will automatically go to the official trustee, who is like a state-governed person rather than a private firm. Private firms will charge more than the official trustee, but the benefit of a private firm is that they're driven then to get payment of their fees. So they're more driven and will strive more to seize and sell assets and to recoup funds and to pay everyone out because they've got their own stake in the game, essentially. So the consequences of bankruptcy are really severe. They're probably the most severe option that we have in Australia. And in terms of restricting lending capacity, the most common means of doing this is, when you apply for a bank loan and you have to tick a box if you've been made bankrupt or if you are bankrupt. Often, as soon as you tick that box, you won't be granted finance. And it's a legal requirement to actually disclose that if you're seeking credit over $6,000. And that's a relatively small amount, $6,000. And the reason that they're rejected is, first of all, the bankruptcy itself. So a person who is made bankrupt will notify the agencies that essentially they're not good with managing their own money. They're not good with repaying debts. They tend to be in high risk situations. And so generally the banks won't want to advance funds to them. And the second one is because in bankruptcy, you're only allowed to keep a certain amount of wages for yourself and to pay your living expenses from, which off the top of my head is about $65,000 at the moment. What the bank is doing is they're not looking at someone with a salary of $80,000 or more. They're looking at someone with a salary of $65,000. And then after you take out all the expenses, what is going to be left to repay what they've just loaned? So generally, credit will be denied. But if it is approved, it's usually approved with very high interest rates and with added security or with a personal guarantee, from mum or dad or from a spouse or sibling. Then we move on to the other way of restricting what a bankrupt can do, and restricting their movement. Bankruptcy is again the strongest way to do this. As soon as someone is made bankrupt, they have to hand over their passport to the trustee in bankruptcy, and that's the person who's managing their affairs. So the trustee holds that passport. And then there's very strict consequences if they breach that. So that's up to 3 years imprisonment if they breach that. And then there's another two parts there which refer to a bankrupt preparing to leave Australia. And it has to be with the intent to defeat or delay creditors. So that can be as soon as you've filed your legal proceeding. If they do it between then and between the court making the order, that's up to 5 years imprisonment. but it also goes back the other way to 6 months before you start that legal proceeding. They're very, very strict consequences, and they're to act as a deterrent to stop people from fleeing. And then we've got another level on top of that. We've got that the court can actually issue a warrant to arrest. So this isn't time in prison, but this is a warrant to arrest. And these, if you have a look at these relate to absconding overseas, concealing or removing property, destroying or removing property, or removing accounts. So where we looked at before, we were looking at there has to be an intention element, an intention to defeat or delay payment. This is far more easier to prove because we're just relying on the fact. All we need to show is the bankrupt has concealed or removed property. That's a fact. So this is going to be far easier to prove than proving an intention, which was the last one. But then here we're getting a lesser outcome. We're getting a warrant to arrest. But it still can stop assets being taken overseas, and it can stop them getting to that point, which was at the start, you know, the case that we had. If we had have come into that 6 months earlier, we could have potentially got one of these warrants to arrest and stopped everything from moving overseas. So this is a really proactive step. The other one is more, once it's already been done, what can you do? So that is bankruptcy, that's the individual. Now we're moving on to liquidation, which is the company. So there are two ways to liquidate a company. The first one is a statutory demand. The other one is a court order, and they both need a subsequent legal proceeding. So liquidation is very comparable to bankruptcy, but just think of it as it applies to the company, not the individual person. So the first way we're doing it is a statutory demand, and this can be done with or without a court order. If you don't have a court order, what you need to do is prepare an affidavit. That's a court document, and that will set out how you calculate the debt and how you say it's owing. So you put all your detail into that affidavit, or you would already have a court order requiring the payment of money. So once you have that and you need to serve that statutory demand, then there's a few options that can happen. The first one, the debt is paid in full, or you reach a payment plan, or they apply to set aside the statutory demand, which you can defend. They're the three options. If they're not complied with, then like before we spoke about, we have an act of bankruptcy. Here, a failure to comply with the statutory demand is an act of insolvency or a presumption of insolvency, and that then allows us to issue the second proceeding, which is the liquidation proceeding. So you'll see a statutory demand is a great tool because it's only 21 days they get to comply, which is a very, very short time frame. The only thing with a statutory demand is it must be an undisputed debt. So they can set aside the statutory demand if they dispute it. Generally, where it's a court order rather than an affidavit, it's not disputed because you've already been through the court process. But where you've got an affidavit, it's more likely to be disputed. And then you've just got to argue about that before you can proceed to either wind up the company, or if that doesn't work, you can go back, start a new proceeding, get that court order, and then go back to the statutory demand. The other way that we've mentioned is rather than doing a statutory demand, it's going with a court order. So you've already been filed a claim in the court, had a defence filed if there was one, and had it heard by a court and you were successful, you've got the court order. So what you can do, if you've got that court order, you can jump to the liquidation proceeding without the statutory demand. Generally, this is more costly because you've gone through one proceeding, now you're going through a second proceeding. It's also more time consuming because you've got the two proceedings, so it can be quite lengthy. And because the statutory demand only requires 21 days or allows 21 days to respond or comply, people tend to freak out when they get it and they tend to just want to make payment. So the statutory demand is a really great facility to use to frighten someone, to get them to pay. And it's also more cost effective and less time consuming to do it that way. So if you've done that, you went to court, you did the liquidation proceeding, and then you're successful, the outcome is that company will be wound up. Generally, that means closing the company down, selling all of their assets, pooling all of that money together and distributing any funds to creditors. So this is virtually the same as what we explained for bankruptcy. Rather than having a trustee in bankruptcy, we've got a similar person, but they're a liquidator. So they take control of the company, look at everything, see what they can do with it, look at any potential claims, and then distribute any funds. Generally, because you're closing that company down, it means that they won't receive any further credit. So they won't be able to get any more funds from anywhere. No one will lend them money. The bank will refuse. But it is less severe on the individual because the company is a separate legal entity to the individual. So the director or the person behind the company is less personally affected as they are in bankruptcy. Bankruptcy is certainly more personal. And for that reason, you know, if you have an option between the two, you'll usually prefer bankruptcy unless all of the assets are held by the company. But bankruptcy really, people want to avoid, they take it personally, their whole life is affected by the bankruptcy. So the other thing in terms of restricting lending capacity is because that business is shutting down, that director or person who ran the company, they were employed by the company, they won't have a job anymore. So liquidation is really a useful tool if it's a small business and the person who is the director is employed full-time in the business. That's how they earn their salary. The other time it's really useful is if it's a family business. You're not then just affecting the director, but they might have their spouse, their children or their parents, their brothers, their sisters, all employed in the company. And by liquidating that company, you're wiping all of them out of a job. And without a job, they're less likely to get any credit advanced to them. On top of that, you can go down the route with ASIC, which is our regulator, and they can actually disqualify people from being directors. So you can disqualify someone for up to 5 years where they've had 2 or more companies go into liquidation in the last 7 years and they've been paid less than 50 cents in the dollar. That's quite common. It can be common in a liquidation for the creditors to get no money. It's up to 5 years as well if they've relied on the Fair Entitlements Guarantee Scheme. So that's FEG, it used to be called GEARS, and that's where employees can go and get paid their accrued entitlements. And the last one is really heavy. That's up to 20 years disqualification. If they've had 2 or more companies failed in the last 7 years, and the way that they've conducted the business has contributed to that failure. So that is just ASIC saying this person can't run a company. So you need to be banned for a good amount of time to go away, do something else, and don't keep trying to bring up new companies and trying to make it work. And then the last one we're going to be speaking about today is injunction. And so what an injunction is, it's similar to a court proceeding, but rather than being 6 months or 12 months or 18 months to be heard, an injunction will generally be heard within a week or 2, or it can even be within a couple of days, depending on how urgent it is. And what you're doing is rather than serving your court documents, waiting for a defense, having, some court hearings and then heading towards a trial, what you're doing is just issuing a very short legal document, presenting it to the court, having a hearing without that other party present. And the reason that the court does that is because it's extremely urgent and it's an extremely serious matter that we want to avoid alerting the other side to. So it's all done behind their back. And the most common, not the most common, but the most severe one of these orders is an Anton Pillar order. And that is a search order. And it's only granted in situations where it's needed to preserve evidence from destruction, concealment, or removal from the jurisdiction. And you'll see, if we pop to the next slide, the court will hear that matter very urgently. They'll create a list of what you can go and take from the premises, or what you can take copies of. Then you can normally execute it, within 24 hours or within 48 hours. It's a very short time frame to execute that. You go to the premises and it's normally a residential address or an office, along with an independent solicitor. You present the court order and then you're allowed to go in and take whatever is on that order. So it means rummaging around some drawers, flipping the house upside down to find whatever you need to find for the court order. So it is a very big invasion of privacy. You get to go in there and, rummage through everything. And if that's someone's house, that can be quite confronting for them, and it's not a pleasant experience for them. So this is, very, very harsh to go and do this. So depending on what the order says, you can actually restrict what they can do. So quite often these orders will involve things like taking away computers or databases. And if somebody runs their business from that, they won't be able to, log in and do the things that they normally do, which will affect their income. And then as part of that order, you can also have the ability to take someone's passport away, which would again restrict their movements. But these are the most serious orders. So the court is quite hesitant to grant these orders without producing quite a bit of evidence. So you need to be able to show that you've got a genuine claim that you need the evidence for. You don't need to prove the claim like you would at a trial, but you need to show the court that there's some reasoning here as to why you need this evidence. But normally, if you don't succeed in these types of orders, the reason that you haven't succeeded is because the court will either not see the urgency. So they'll say, can you get the evidence another way? Is there another means by getting this evidence where, although a copy might be destroyed, you've still got the original, or you've still got other copies? or what the court will say is that there's not enough evidence to show that it's actually imminently going to be destroyed. So you do need quite a bit of evidence, but that's obviously balanced against the seriousness of these orders. So that is the end for us. What we're going to do is Jodie's going to pop in our chat box our dispute resolution guide, which we've got. It's a free document for you to download if you'd like to learn some more tips about dispute resolution, about the court process, and about settlements. Have a look at that. It's a really useful tool.
Right. Hey, thank you so much for that, Erin. There were some questions that came up during the session. The one was, and it goes back to the restricting of movement, and specifically, you know, it's twofold. So, like, what happens if they don't give over their passport? And the question in the Q&A was, can you ask for the passport for non-Australians? So if they're here as an American, can you take their American passport or what have you? So 2 questions for you.
Yeah, so my understanding is they can take whatever passport you've got, whether that's Australian or an overseas passport. So if you want to go overseas as a bankrupt and you've already handed over your passport, then what you have to do is go to the trustee in bankruptcy, explain why you need to go overseas, you know, what you need to do, and they can either decide to give you your passport and grant the travel, or to not do that, or they can agree but with certain conditions imposed on your travel. If you're not happy with that outcome or your passport's refused, you can actually go to court under an application and request the court to make a court order as to whether to release your passport. It's an area which could potentially change. There's been quite a lot of argument about whether taking the passport of a bankrupt restricts their right to movement, which is a fundamental right. But it's here, it's hanging around. But what the courts look at is there a legitimate reason to travel? Is the bankrupt actually going to come back? Is there a reason to believe that they might not? And will them going overseas impair the trustee's ability to manage their financial affairs and the distribution of those funds? So they have to hand over their passport, but they can still travel with restriction or with by the trustee or with a court order.
Okay. All right. Thanks for that clarification, because it was something that had gone into the Q&A, but also had a private chat as well come through from somebody. There's another question that's come in the Q&A, but I'm going to put a quick and easy one up here first. If I'm already owed money, will I be able to add the cost of bankruptcy or insolvency to that debt?
Yes, so you can add the cost. So once you've got a debt, you'll have interest which accrues on the debt, and that continues to accrue until payment. When you start bankruptcy and insolvency, you do, it's a legal proceeding, so you do get some costs. Unfortunately, bankruptcy and insolvency are quite expensive areas to pursue. In terms of just a court filing fee, it's one of the highest court filing fees of around $4,000 for companies to pay. And then, so once you get that back, you get your filing fee back, and then you get normally a fixed amount from the court, which is between, I think it's $2,800 for bankruptcy and about $4,500 for insolvency, plus the filing fee. But of course, that's all dependent upon when the trustee or insolvency expert when they take over, is there enough funds to pay you your debt and to pay that court, the legal costs on top of that? That all depends on what they've got to distribute.
Right. And I think, Jody, you're going to take the question that's in the Q&A.
Yes, I will. So hopefully I get this right, Erin. So it's on the fly. If the debtor who signed a contract is an empty company, but the main business, and it's run under a different director's personal ABN, can we go after the director's assets? That feels like a curly one.
Normally, whoever signed the contract is the debtor. That's the person that you've got the claim against. That's an empty company. So pursuing that, you might not ever get paid. You might not get anything out of it. In terms of that, there might be a benefit in making that insolvent. So in pursuing that liquidation process, because of one of the other things we talked about, like the director working in it full time, they'll lose a wage, or if they've had other companies go under, and this is the second one in 7 years, you might be able to get them banned from ASIC. So you might be able to work with it that way, but it is less likely to get you any money back. What I would look at doing is, rather than, so you need to be then creative in your claim. So rather than having the claim against that empty company, what I would want to do is have a look at your emails and invoices and see if you can make an argument that the true customer was the other company or was the director personally. So if you get emails requesting your services or goods from the other company, you can potentially claim them as your true customer. Similar with the director, if they've emailed you personally, or if they've signed a personal guarantee, then you can pursue them. So I would want to widen that pool and the argument to be, rather than the company being rather than the debtor being the empty company, we want to widen that to see if we can bring in anyone else who received a benefit from the goods or services. That's the way that I would do it. And then I would do that in a legal proceeding, not in a statutory demand, because that's going to be disputed. I would do that in a legal proceeding and then see what defence they come at you with. But if the claim isn't particularly strong, I'd expect to settle somewhere along the way and not need to go all the way to bankruptcy or insolvency.
Right.
Brilliant.
I guess one of the questions that does come up in terms of, or the reluctance, is that, lawyers are so expensive, because we always tease you about billable hours.
But no, they're not, are they? No.
Present company.
No, Wendy.
But I think it's around some of these people, you kind of think, oh my gosh, I'm owed money. I don't have money to spend. How am I going to go about recouping money? And it's like, and I look at some of this stuff in terms of, all right, so the statutory demand, well, that seems like a good stick to use kind of in most cases. But, I guess it's kind of like, what are some of the things that we as businesses or as individuals can do to prevent some of this stuff in the first place? And I'm assuming good terms and conditions or something, but, because this is, what we're talking about are the extreme cases, but what are some of the things we should be thinking about to prevent some of this?
Yeah, so there's a lot that you can do yourself to prevent getting to this point. You want to have a lot of proactive things in place. My number one thing is get your terms and conditions right, because if you think about it, that is governing everything that you do in your business, from payment to liability to refunds, defects. It covers everything. So get that document right. Other things is just have really good procedures in place for signing up clients, asking for a deposit is a good one, or holding your goods or services until you get payment in full, then releasing them. You've got other things you can do, like making sure you do a credit check on any new customers, particularly the ones that come back with poor credit ratings or defaults, get those payments up front. You can also make sure, it's a very simple one, but people forget to do it, make sure you get their contact details, email, postal address or residence details. Make sure the terms and conditions are signed. There's things we can do if they're not signed, but having them signed is the best case scenario, puts you in the best position. And then then after you sign them up and you're delivering everything, make sure you've got processes in place to actually follow up the invoices. You know, a phone call and then an email and then a formal demand before passing it on to a lawyer. So you've exhausted as much as you can.
Okay. And I think that there have been a number of businesses over the past couple of years that have probably gotten themselves into strife, you know, and maybe their credit rating isn't good, but they're starting to come good, but they still have the lingering effects of a bad rating. So getting payment in advance is I think, a good way to kind of do business. And we need to help everybody trade through all of this. But in the chat, a question has come up in terms of, if we are requesting a deposit, what are the legal requirements that must be adhered to if you are taking a deposit?
Yeah, so it depends on, you've got a few different parts playing. You've got the industry that you're in. So say for lawyers and real estate agents, you've got to comply with trust obligations. If you're not covered by that, then you've got your terms and conditions, and that should set out when the deposit is due and what circumstances it will be refundable in. That's your complete obligation there in your terms and conditions. Then overarching to that, you've got the Australian consumer law, which governs a little bit of deposits, but ultimately you do have to give a refund if there's a major failure or major defect in your service or goods. So first position is terms and conditions. Take the deposit, hold on to it, deliver the goods or services. Then if you were to get a claim that your goods and services is defective or there's something else wrong with it, then consider that consumer law overarching requirement and whether you do have to give a refund. But terms and conditions, get your deposit in there, and you can put in your terms and conditions that it's only refundable, you know, if there is a major failure or if you can't deliver the goods or services. But if the customer, you can certainly have in there that if the customer doesn't proceed or doesn't give you everything that you need to complete it, that you can hold that deposit. You can have that all in your terms and conditions.
Brilliant. Going back to ensuring that we've done some credit checks, what sort of tools, was in the chat, in the Q&A, thank you, good question. What sort of tools can we suggest for doing a credit check and the businesses can implement? We have a number of clients that have got a credit application, and I'm curious as to what tools they would use. So what could we recommend?
Yeah, so if you've got an insurer, like a debt recovery insurer, they will do their own checks for you, which is really helpful. But if you're just doing it yourself, if it is a company, if you do an ASIC search of the company, but you do it through a provider like InfoTrack, who we use. So you can go on the InfoTrack website or, you know, add them on as an app to what you do. And then after the end of the ASIC search, it has on the end the defaults, the amount of the defaults, who's been searching or looking at the defaults. And that's very useful information. And it also comes at now with a credit score indicator and just a graph, which is really helpful as to where a business like them should sit, what their credit rating should be like. And then it will go down to, yellow, orange, and red if they're really not good. So you can get an indication from there. You can also search for individuals' AFSA. You can do a bankruptcy search in AFSA for the individual, and that will pop up if they've ever been made bankrupt. You can search their name. Other things that you can do, not necessarily a credit reporting agency, but through searches. InfoTrack has another ability for you to search property ownership through an individual's name. So you can search to see if they own any real property. You can also do a directorship search to see what directors' positions they hold. And so, if you're doing that for new clients signing up and you see, oh, they own a house, there's probably, although you don't know how much it's mortgaged, there's probably enough in there that you can seize and sell it if you need to, or even just the threat of doing that would prompt payment. Worst case scenario, if they do go to bankruptcy, the trustee will sell that house and distribute the funds. So, you're more likely to get payment out of someone who has, say, a property. And if you do that search beforehand, it'll give you a bit more peace of mind.
I've just popped in the chat the link to the ASIC searches that can be done through InfoTrack, which is a company that we use and who are reputable, and it's instant. And I saw on there that you can get a free ASIC search of a company. So for that person that did the Q&A, if you've got a company in mind, you can do it for free the minute you get off this webinar.
Yeah, and they're only like $25 for a current one, or about $50, and you can get all the history of the company too. So, it's pretty cheap if you're doing that before signing up a new customer.
And I think, this is something that, I'm delighted, Erin, that you are an expert in this, because it's not something that I ever want to be an expert in. And so I think that all of these, the information that you've put into the chat, that's great. Thank you so much, Jody, for manning that for all of us. Are there any other things you kind of think that, we spoke a little bit about the terms and conditions, there's the searches you can do, there's the dispute resolution. Is there anything else that, I'm just mindful of the time, that you would add as some closing thoughts?
Yeah, the only other thing I continue to advocate for the terms and conditions. But what I would have in there is, we spoke about, if you do go down bankruptcy and insolvency, the fees are quite high to go down that route. So having in your terms and conditions an indemnity clause, which says, if you breach these terms and conditions, you will pay our legal costs and expenses on an indemnity basis. What that means is, rather than just getting that small amount that the court orders, you have an argument for all of your reasonably incurred legal costs. So just in terms of bankruptcy and insolvency, that could mean an extra $6,000 to $8,000 just for that process. And that's not including the initial court proceeding that you did, or the statutory demand or bankruptcy notice. So generally, where the court awards costs, you might be looking at about 50% out-of-pocket costs, whereas with an indemnity clause, you're looking at more 80-85% out-of-pocket costs. So there's a big difference.
Yes. And that was, that's what I was, because it's, it's a risk reward situation. At some point you're going to have to figure out, is the debt worth chasing, and sometimes it's just not going to be. But if it is, then you need to have made sure that you had all of your ducks in a row to begin with the terms, etc. And then it's kind of, I guess, it's engaging with legal experts, because if you don't do it, if you don't start the process correctly, I'm presuming that too can have some dire and expensive costs, and maybe, make it even more challenging for you to get the funds because the game's afoot. Maybe they're already fleeing.
Yeah, that's right. I think doing a demand yourself is really great. Whether that's an email or a letter, doing that, just seeing if you get payment, even if it's a small debt, you're working anyway, just pop that on top of what you're doing. Then I would say get a lawyer to do a letter of demand, which can still be relatively cheap. And then at that point, making a call, is it worth pushing it further? Because any further than that, you really do need a lawyer involved, because it is very strategic which route you go down from there.
I've just popped in the chat some more tools. We're full of tools and practical tools for all businesses here at Taurus Legal Management. I've just popped in an article that we did recently on terms and conditions, which Erin actually wrote. It's a great article. All business owners should read it. And they're key terms that should be in that document. So check that out as well. There's lots of other tools on our website you can have a look at as well.
Perfect. All right. And there was one last question that kind of slipped in under the radar. So if somebody does become bankrupt, how long do they stay bankrupt? How long does that follow them?
Yeah, so it's 3 years and a day is their actual bankruptcy period. And that's if they have a lot of assets which can be sold and distributed before that time, they can annul a bankruptcy early. That's very, very rare. So 3 years is kind of the expected time, but that can go on for years longer if they're, a bit naughty and don't comply or don't disclose assets, really try and resist the bankruptcy process. It can, get added on, but they'll forever be on that list of bankrupt. So you'll always be able to find them on a search.
Right. All righty. Well, thank you so much. We're just coming up on 6 o'clock now, so we will go ahead and conclude this. Erin, thank you so much for your expertise and your generosity and your patience and actually just simplifying something that can at times be a bit daunting. Jody, thank you so much as well as being my co-pilot. And for the attendees, we certainly appreciate you being here. I will send through some information over the next couple of days with Erin's contact details and once again with some of those resources. And stay tuned for more upcoming webinars from Victory. Thank you so much, everyone.
Thanks,
Have a good
Wendy.
night.
Thanks, Wendy. Thanks, everyone.